Good morning, you're Travis Shoemaker. Speak up, please.
Yes, ma'am.
And Mr. Shoemaker is currently on probation for the offense of injury to a child. That was a 5-year sentence that was probated for 5 years. There was a motion to revoke that probation filed, and we were here previously. Mr. Shoemaker pled true to counts 1 through 9, which include...
With the exception of 7, Judge. It was 1 through 6.
Sorry, you're
8
correct.
and 9.
Thank you. 1 through 6, and then 8 and 9. Just for the record, those include failing to report, failing to do community service, failing to do intensive outpatient treatment, failing to complete the battering intervention program, committing the new offense of domestic violence and false imprisonment in 2023 in San Francisco County, California. Has everyone had an opportunity to review that updated pre-sentence report?
Yes, Your Honor.
Are there any additions or corrections, Ms. Holmes?
No from the defense, Your Honor.
Mr. Hoffpower?
Not for the state, Your Honor.
And this was just an open plea, correct? Was there an agreement?
It wasn't an agreement, Your Honor. It was unagreed.
That's what I thought. Okay, Ms. Holmes, you may proceed.
Yes, Your Honor. I've met with Mr. Shoemaker in regards to his violations with probation. Biggest issue is absconding and leaving the area, in which he at some point had to be extradited from California. Mr. Shoemaker explained the reasoning why he was there, stating that he did contact probation or to let them know that he was needing medical treatment because he was not getting the appropriate treatments locally, and so he decided to go elsewhere, and that's how he ended up in California. I think he does have family out there as well. One of the biggest issues, Judge, in my meetings with Mr. Shoemaker is mental health. It is my understanding that he was extended so that he could participate in some mental health treatment. I do feel that he does need to continue to have some type of mental health treatment. He is asking to be continued on probation so that he can get the appropriate treatment. In addition, maybe the court could consider the cognitive track of ISF as a means of helping Mr. Shoemaker get back on track, as well as if he does have that opportunity to continue to have the GPS monitoring, because we do know that the concern is him being a flight risk. And so I've explained to him, and he would be in agreement that if the court gave him that opportunity so that he could get his mental health back on track and to try to complete probation, that the GPS monitor is appropriate. I've also explained to him, because he had made a statement in regards to wanting to go to Hawaii. I personally told him that's not happening. And he then stated that he is willing to remain in Jefferson County and would seek help or additional aid so that he could have the appropriate housing to remain in Jefferson County, unless he is given some type of approval to travel. But Your Honor, Mr. Shoemaker is asking that the court give him another chance to get his probation back on track and to get the assistance of mental health treatment.
So, and real quick, Mr. Hoffpower, I probably can...
You understand. You want me to...
Well, I just want to make sure, I'm looking back at the original pre-sentence report, and none of these issues are new issues. The mental health issues, any drug, that was all addressed in that original report, and the supervision plan included the requirement and the order that you enter and successfully and follow any services that's through Spindletop. And so you were given all of those opportunities from the beginning. So asking for them now, I mean, that was already done. And it's not just like you left, I don't know what this health issue is that you think they can do better in California, but you went to California and obviously didn't get better because you committed the new offenses of domestic violence that, I mean, appear pretty serious. Mr. Hoffpower?
Your Honor, and I want to make sure that the court, and I want to take judicial notice of the updated pre-sentence, but it's included in there, is that he's gone to California twice and has been extradited. He went first time and was brought back, and in 11/30 of 2023, he was extradited back, and then when the court allowed him an extension. It went from a deferred to a straight probation. That's when the mental health stuff was applied. He didn't comply and actually was caught in California again
You're right.
without, he looks like for maybe a month he may have reported. He
I mean,
he absconds every
So
time.
twice. So, I mean, at the original pre-sentence report, when he first got on probation, I said, let's help you out. That's what you needed with services. Then you left, and sometimes I look back at what I let people do, and I wonder what I was thinking. Because you went to California, came back, said, I need mental health treatment again, and I said, okay, and now it's the third time you're saying that after we've had to go get you in California. Is there anything else, Ms. Ruiz, that's not in that updated report that you'd like to add? So, Mr. Shoemaker, anything else, Ms. Holmes?
Yeah.
At this time, I'm going to find that you entered your pleas of true, again, to counts 1 through 6 and 8 and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation. Sentence you to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. This is not a plea agreement. You have some limited rights to appeal. You can talk to Ms. Holmes about that. I'm handing you that admonishment. Ms. Holmes, if you'll get signatures on that and then get the bottom copy. I'm also going to hand you, Mr. Shoemaker, let's see, I probably did this back in 2022. When you were initially placed on probation, I'm not sure if I did that back then when we started, but because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that written admonishment I provide you to make sure you understand that law, okay? And once you sign that, we'll get you a copy of the certification, and then you can go back with the bailiff. Thank you, and thank you, Mr. Ruiz. Good morning, sir. You're Terry Rose.
Yes, ma'am.
And in cause number 24, DCCR 1369, Mr. Rose is charged with first-degree felony offensive murder. And Mr. Roundtree, what is the announcement? Mr. Nichols, where are y'all?
Your Honor, I tendered to Mr. Roundtree today in court updated discovery.
Okay.
That had come in. It was pretty voluminous, and we put it on a big thumb drive form and gave that to him today.
Do you anticipate anything else coming?
I do not, Your Honor.
Okay.
And I haven't had a chance to talk to Mr. Nichols. I did briefly go through what he tendered this morning, and there may still be some outstanding discovery, but I can get with him and send him an email what I believe may be missing.
Okay.
But I don't want to represent that to the court.
Sure.
But
Until you can have a
just
chance.
based on what I reviewed this morning.
So realistically, for you to go through that, to get some other things involved if you need, what I'd like to do is maybe just a 60-day reset instead of a 30-day. That gives you time to go through everything, make any requests to Mr. Nichols. If there's something you need to go out and try to find, get that. And then I'll review the motion and get what you need to hopefully get a announcement maybe at that next court date.
Sounds good, Your Honor.
Okay.
That's fine with me, Your Honor.
Okay, perfect.
Thank you.
Thank you, Ms. Rose. You can go back with the bailiff. All right, sir, are you Christopher Wade? And will your client waive the formal reading of the indictment?
He does, Your Honor.
Mr. Wade, in cause number 24, DCCR 0264, the state is elected to proceed on count 1 only. It alleges you committed a third-degree felony offense of evading arrest or detention with the use of a vehicle. And that is from December 29th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Samuel? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Wade is not competent?
There's none.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive that credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, so you should read that written admonishment I provide you to see what devices qualify as a firearm. And if you have any questions about how long that lasts or anything about that, you can talk to Mr. Samuel, all right? All right, good luck to you, sir. Thank you, Mr. Samuel.
Thank you. Thank you, Your Honor.
Good morning, sir. Are you Brandon Dodd? And Mr. Dodd, in cause number 24, DCCR 2418, you're charged with the first-degree felony offensive murder, and that is from October 14th of 2024. Your indictment alleges that you were previously convicted of aggravated robbery February 22nd of 2005. And what that means is that if, I'm sorry. Yes, sir.
The state has also filed a notice of habitual offender. We've alleged an additional felony offense. Electronically filed and served it on Mr. Reynolds
I've got
as
it.
well.
I've